What do you do with respondents' argument that this is merely an application of our precedents?
I don't think it is an application of this court's precedents, Your Honor. And Justice Thomas, it's because this court's precedents in McDonnell-Douglas lays out a framework, and then McDonnell versus Santa Fe Trail says they apply to the same terms and same standards. But the background circumstances rule isn't the same term. It's not the same standard. The Sixth Circuit says it's an additional burden. And in prior cases, it says it's a difficult and more demanding burden on majority group plaintiffs. So I don't think it's consistent with this court's precedents.
What if you have a situation where, say, 60 employees in the company, say, a half dozen African Americans, an African American applies for a job, there's an opening, he doesn't get it, remains open for, a couple of months. Does that satisfy the prima facie case? He said it was because of discrimination.
Assuming that they are qualified and yes.
Okay. Now, I'm sorry. That's a yes?
Yes, that is true.
Okay. Now let's say it's the same thing, but the applicant is white. Exactly the same facts. And she says, I lost the job because of discrimination on the basis of race. Does that state a prima facie case?
I think it states a prima facie case, but I think it goes, and perhaps, Your Honor, it goes to the idea of getting employers to come forward with an explanation and then providing sort of a legitimate non-discriminatory reason, which I don't think is a high burden at all. I think as Reeves, as Burdine, as Frunco make clear, they just have to provide some sort of legitimate non-discriminatory reason to answer or to rebut the prima facie case.